Yeah, I know. Yeah, Arizona's tough. We had a depot out here. Remember that? It was like 120 something degrees. It's horrible. Yeah. Okay, you're good to go. All right, you guys. I'm glad that everybody had a chance to chit chat, meet each other. I saw you all interacting. That was great. That's what you need to do. There's a difficult situation to be in when you're involved with this agency, with DCS or CPS or whatever you guys call it, wherever you are. And it's important that you get together and network and support each other, because nobody else will. And it's sure. It's really up to you to form up your own community, your own support groups, and try to help each other out. And so I was just saying, when I walked in, I saw everybody chit-chatting and talking, getting along real well. That was really good, and that's what you should be doing. So anyway, I promised you that we'd have a few minutes between each segment for questions. So before I get to you, I know you're excited. Somebody, I'm looking for him, had a really good question on 11th Amendment immunity. Where'd he go? There you are. There you are. During the break, the question came up, and it's specific to Arizona, but it covers other states too, depending on where you're at. And basically the issue is the 11th Amendment prevents you from suing the state for damages. You can still seek an injunction. You can get an injunctive relief, but that doesn't really do anything for you. It may help, people down the road. For example, what we're going to be doing in Arizona, we're going to be seeking an injunction to force them to start training their people about the 4th and 14th Amendment, and that they need to get warrants before they take kids if there's not an emergency. And we're also going to try to get an injunction to force them to promulgate a policy to that effect. So that's injunctive relief. They're not immune. They got to follow the law like everybody else. And that's what you seek against the state. The way it works out in California, and it differs by state, so it's going to depend what state you're in. But in California, there's the social services. It's Department it's CDSS out there in California, but they don't actually go out and seize kids. What they do is they really just administer regulations and funding. And the counties, the county governments, are the ones that actually go out and seize children. The state just funnels the money to the counties depending on how many kids they have in their system at any particular time. That money, the money the state funnels to the counties, comes in part from the state and in part from the federal government. So really the state sort of acts as the gatekeeper of the funds, and then the counties on a local level administer the program. And by administer the program, I mean go out and seize kids or do what they do. Arizona's different. Other states are different too, where it's actually the state that goes out and administers the program. They get the federal funding, and then they'll go out and administer the program. So for the attorneys out there that are from other states, you have to take a really close look, because this is a trap for you. You have to take a really close look at how your agency is administered. Is it done by the county with state funding, or is it actually administered directly by the state? And you want to be careful about that in your pleading, because if you go and you plead a damages claim against the state, then you're going to get blown out and look like an idiot. You don't want to do that. Another way to get around or deal with the 11th Amendment immunity issue, and we haven't tried this yet in Arizona, we're considering it, maybe for our next case. But one thing that you might try doing, and I wouldn't recommend this for any pro per parent or grandparent or any pro per plaintiff, because you're going to get stuck in a situation, if it works, you're going to get stuck in a situation you don't want to be in. But for the attorneys, what you might try doing, if you have a good liability claim that's tight, you might file in state court against both the state and the individual officers, because then you don't have the 11th Amendment immunity issue, and you're still going to be able to go seek damages for the constitutional violation. Just intuitively, what I would think would happen in that circumstance is the state would probably remove to federal court. But the cool thing about it is when they remove, they waive 11th Amendment immunity, right? They voluntarily subject themselves to the federal system, thereby waiving 11th Amendment immunity, so you got them. And we may try that on our next one. I don't know, he's probably listening here, so he'll know that he doesn't want to remove it. We have, the attorney we're working with is a guy named Jim Bowen. And yeah, he may think about that. I don't know. Probably shouldn't have said it. Did they remove?
They do remove, but they know they've waived their 11th.
Okay, yeah, as long as they remove, that'd be great. See, what I would do if I were them, I probably shouldn't talk about what I would do, right? Right. Right. I would do things differently if I were them. That's probably enough to say. But yeah, if they remove, floodgates are open. You go after them on everything, and they've waived their 11th Amendment immunity. So that's the way I would deal with it out here.
Problem that they're not a defendant for Section 1983. There will be
Well, this is the thing. They may not necessarily be a defendant under 1983, but they can still be a defendant for violating your constitutional rights, right?
And for good state law claims.
Yeah, that's another thing. When we're talking about pleading these things, I'm glad you brought that up. When we're talking about pleading these claims in federal court for pro pers, I don't mean for you to understand that you can only plead your federal 1983 claim, because the federal courts have what's called supplemental jurisdiction. So long as there's some court claim that confers jurisdiction to the federal court, they'll also consider all the other stuff you can throw in there. So if you have state law claims, state civil rights claims, state constitutional claims, you can put those in your federal pleading as well, so long as you have at least one federal claim that survives. So, and that's supplemental jurisdiction. Yeah, you've been waiting a long time. Go ahead. 50 words or less.
Yes, I have that.
All right.
Okay, so I am disabled and my son is disabled. My daughter is almost 18, so she's fine. But my son is...
I'm on this active case. I need to make myself aware.
Okay.
Sorry.
Just hold on. Yep. Well, actually, you know what? Hold on a second, because we're actually recording. And this is what I want to do with the questions, is I don't want anything that is case specific or fact specific to your situation. What I would like to do is focus just on litigation issues. So litigation for civil rights cases. So if you're still in dependency, still in family law, this is the wrong place to ask those questions.
Right. I just wanted to know, how do you prevent DCS from coming back after they have, you know what I mean?
After they've done whatever they've done?
Yes, because that's coming.
Yeah, I can tell you can't prevent them. and I'll give you an example. I have a case, this was years ago in 2009. You can tell her to come back. Can somebody tell her she can come back in? Yeah.
Well, I actually have a question, and she's also.
If it's
It's not case related, it's already over, but I'd rather.
She's a good use.
why don't we just ask it privately then?
Okay,
I don't want anybody excluded here.
no problem.
Yeah. So if you have any specific or personal issue, we'll address those privately.
My other question has nothing to do.
Okay, that's fine. I just don't want anybody excluded from the group. That's fine. So the question was essentially, can you do anything once you've resolved your issues with DCS, even after you've sued them, to keep them from coming back and hitting you again, right? And
Besides leave the state.
you know this is the deal. I'll tell you what I tell my clients. And you take it or leave it. You can put 15 attorneys in a bag, shake it up, and get 50 opinions. So it's worth what you're paying for it. How's that? But what I tell my clients once they get their kids back is to just get the hell out of Dodge. Just move. Just move. Because there really is nothing you can do. If DCS, or out there it's DCFS in Los Angeles, if they want to come after you, there's nothing that's going to prevent it And you can sue them all you want. I was going to tell you a story. I had a case in 2010, horrible case. And 2 kids seized from school without a warrant. DCFS didn't bother even telling the parents what had happened. They filed a missing persons report. I mean, there's all this horrible stuff going on. They find out a couple days later their kids are in foster care. So they get the kids back. They had a really good judge that went through with the social worker actually line by line and found everything specifically on the record, found everything she said was false, and ordered the kids given back right away, and they were given back. So then they got a hold of me and we said, oh yeah, okay, let's sue them. They blew it. And so we sue them. And the kids were only gone a short period of time, a few days. And so we sue them, and we end up settling the case for like $250,000 or something. And right after the check cleared, DCFS this time went and got a warrant for the identical allegations based on the identical facts. The original judge was on vacation at the time, so she couldn't look at it. And they got a warrant, and they went and kicked in the doors and seized the kids, and they never got them back. So there's horror stories out there. These agencies can be retaliatory and vindictive, and you just have to keep that in mind.
I have a question, just curious. Are kids safer in private school or versus public school?
What do you mean by safer?
So, for example, I've been through a little bit of child pornography, but I'm on the other side. I personally think that my children are safer in private school, meaning that they're not so connected to the system. Does that make any sense?
Well, I understand your question.
I feel like if my kid shows up to school at a private school with like a black and blue mark on her leg because she was messing around on her roller skates.
They're mandated reporters.
Okay.
All of them, public, private, doesn't matter where, they're mandated reporters. Where the difference is between public and private school is that the public schools typically will cooperate 100% with CPS when they want to come and interview a kid or whatever. They'll just open the doors, let them in, and do whatever you need to do. The private schools, and I forget the name of the case, there's actually a case on point. The private schools do not have the same obligations in that respect as the public schools do, and depending on your school, they may not permit the police or DCS or whoever to interview the kids at school without your permission or a warrant. So there is a difference between the two, but it's not what you're thinking. All teachers are mandated reporters.
If my kid shows up with a black and blue mark, they're going to be like, all
You got the same problem. They're all mandated reporters. Yeah.
Kind of connected to that. So is the reverse Miranda rights, like that the card your kids can carry, I don't know.
All right. There is no Miranda right for parents and kids involved with DCS. They're not required to disclose to you that you don't have to talk to them. They're not required to disclose to you that you don't have to let them in your.
They have a card like that I've seen.
Who?
The kids carry on them, that basically says that. And
well, that's something parents would have cooked up on their own. That's not something that I've seen that's recognized in the law.
they can't hear back here, they're saying.
Yeah, I can repeat the question. The question was relative to kids carrying around a little card that basically has like Miranda type language on it. And
Kids get scared. I think kids get scared.
sure, but there's no, I understand, but there's no legal requirement that I know of that requires a social worker to tell the kid or the parent or anybody what that person's rights are during the course of a DCS investigation. Doesn't exist yet. That doesn't mean it's not going to exist, but it doesn't exist yet. Okay, let's just legal questions. Go ahead.
I want to know, I'm new to all of this.
Okay.
And I want to know, we're used to in Arizona here, our legislature moving monies around that have been allocated for different things. Is there a money component that the office
Okay.
does? They get more money?
The question is there a money component that drives, am I getting that right? That drives DCS conduct? Well,
Big time.
If they don't use it like for the reunification of things, they
All right, hold on. You guys want me to answer the question or not? All right, I'll answer the question from my view once everybody's settled down a little bit. All right. Yes, there is a financial component. The way that the system is set up, and I think I have a bunch of this on the Families Against Government Abuse group. We uncovered a lot of stuff during the Duvall discovery out in this trial we just finished out there. And one of the things we discovered that was really interesting, and I mean, we've known all along that Title IV-E has a bunch of funding streams from the federal government. We know that, you know, CAPTA has funding requirements, things like that. But we never really put two and two together to figure out what that all meant. And we uncovered a training document with the County of Los Angeles, and it's called Title IV-E funding. And essentially what it says is if there are no findings, you don't get funding. And that is at every stage in the process. From the moment that a hotline call comes in, there's a funding stream for that. Then for the investigation, there's a separate funding stream for that. Then when we go out and seize the kid, there's a funding stream for that. And there's this whole series of events that happen all the way down the road once the courts get involved, and there's funding for each hearing event. And what the rule is, we had a guy testify to this, a guy named Jerry Dominguez. He's on line, I think he might be in the Facebook group, is that if there's no finding from the court, there's no funding. So what does that tell you? And they give this training. This is during, I think I've got her posted online, is Beth Miner, videotape deposition of Beth Miner. And what she says is that they only give that training to supervisors and above. They don't train their line workers about the funding stream. And I was thinking about that. Why would you not train everybody? And it's because I think, and this is just my opinion, my theory, I don't have anything to back it up, that the reason that we train management about the funding is because management has a stake in keeping the funding going. And the line workers, they're not necessarily bad people or anything like that, and they aren't going to be out grabbing kids for, you know, just willy-nilly reasons. And if we sit there and say, hey, you better grab these kids because if you don't, we're not going to get this money, you know, that might not sit well. I don't know. But at the management level, it's a different story. There's different considerations involved. So, I mean, that's just my theory about why they may train their supervisors and managers to go out and, you know, get kids. And if you take all of that, I'm not quite there yet. If you take all of that and couple it together, there's another deposition we put online. It was the director of Orange County Social Services Agency. And if you put all that together with his testimony, he's under oath, what he said is that they start with a basis. And their basis for this year is determined by what they did last year. And what that means is this year, to keep the same funding level that they got last year, they have to have the same number of kids. The funding metrics is driven by the number of kids in the system. So, and I asked him this, I said, well, what happens if, you know, next year there's just not as much trouble, you don't have as many kids? He says, well, I have a real problem, because we only get funding from the federal and the state governments based on number of kids, and our basis is set for based on what we did last year. Next year, the county, out of its general fund, is going to have to pick up any shortfall. If that happens, I may lose my job, right? So, and then we got into overhead issues. So, well, why can't you just cut your overhead? He says, well, all of my social workers are government employees. I can't just fire them. So if we don't have kids, they're going to be sitting around. I'm going to be paying them anyway. And I can't get rid of the buildings. Those are fixed assets. So he's stuck. He has a fixed overhead. And if he doesn't get enough kids to at least meet that fixed overhead, they're in trouble. He may lose his job. So that's problem. That's problem. Yes.
Sean, I can report to you that one of the things that happens almost like clockwork in DCS hearings is the ASCA findings. You better believe that that's put in front of the judge. Judge, we need the finding that the state has made reasonable efforts to present these things, whether it's junk or not, and the judges sign them like clockwork.
All right, I'm video recorded, so I'm not going to say anything about that. But what I can tell you is yes, that's one of the findings that's on that nice little training sheet. No finding, no funding. Right. That is one of the findings. And what we frequently see, I don't know how they run it out here in Arizona, but in California, it's all on a computerized system. And they hit a little button, and it just generates this minute order that has all the perfect language they need. And that's it. I'm absolutely positive that the judges do their job and that they review all of the information in front of them and that their findings are correct. So that's just a...
They're supposed to go through and make sure that the boxes are checked. They're produced on pleadings and with the Attorney General's office heading and presented to the court, and that's what we usually argue in court.
Okay. So you guys are a little bit different out here. It sounds like the state actually works up the order, and then have you ever had a circumstance? This is like, I know I'm not supposed to ask questions, but I have a question. Do you ever have circumstances where the judge will not agree with the finding?
I have. I do. My practice specifically does juvenile cases here in Arizona. So I've actually asked for not only a finding of no reasonable efforts, and I've had a couple judges actually stay the reasonable efforts findings until the next hearing. And then so also if I come back later, I can ask for a tolling of time.
Mm-hmm.
And there's other things that I built off of that when I'm representing parents. So it's kind of a complex thing. Another problem with the system here is the Attorney General's office. There, from my information, is funded. The general fund comes out of DCS's funding source, unlike
that makes
the
sense.
rest of the other agencies within the Attorney General's office. So it's a little.
Do you know out here in Arizona whether or not that is also the matrix for that funding is also driven by the number of kids?
Well, as a former Assistant Attorney General, we need to talk after the hearing because you are on camera.
Okay. Fair enough. All right, let's just do two more questions and let's move along. Well, I know everybody's been waiting. Go ahead. Go ahead.
In the state of Arizona, it's a Class 1 misdemeanor to make a false report to the Child Abuse Hotline. In August of 2015, the DCS came out making a statement that to the recording in the hotline that it is a crime. Okay, nobody has been prosecuted for that since I've been doing this for the last 5.5 years.
All right, where's the question?
The question is, why has that not been part of your injunctive relief or somebody's injunctive relief on the federal level?
All right, okay. I think I got the crux of the question. Is that you guys have a statute out here that prohibits or makes a crime the false reporting of suspected child abuse. Did I get that right?
Yes.
Okay. You know what? That's for somebody else, really. We don't have that out there, and I'd be very surprised actually if it's worded the way you think or the way that you're interpreting it. Because what we want to do generally as a society, you might not have noticed this or thought of it, but I am not anti-social worker, anti-CPS. Okay, we as a society, we want our kids to be safe. And I don't think there's anybody in here, and if there is, let me know. I don't think there's anybody in here that would disagree with me that there are kids out there that need to be protected, and to protect them, we need to know about them. So hold on. So as a society, what we do is we have laws set up to encourage people to report. And we want them to report maybe even more than they should, so that none of these kids that really do need the help slip through the cracks. So that's what sort of drives all the mandated reporter statutes and everything else. And I don't know how they have it set up out here in California or in Arizona, but in California, so long as it's a good faith report, you're going to have immunity from civil litigation. Okay? We don't have, at least insofar as I understand it, we don't have any statute that makes it a crime for anybody to report to the child abuse hotline. And certainly, in fact, that's the opposite for mandated reporters. If they do not report something that should have been reported, it's a misdemeanor. They can run into licensure problems. They can run into all kinds of things. So I haven't looked at the statute you're talking about. I don't want to argue about it because I haven't seen it. But, you know, it doesn't really make sense to me that there would be a criminal statute for that. The relief would really be to sue the false reporter for some sort of defamation or something like that.
Hotline reporting in the beginning, so I'm actually agreeing with the department that these need to be prosecuted. They said in the news article, which was AZ's, I think, that they do get false reports, and this has been a year and a half. Nobody's been prosecuted, and
sure, that's a better question to ask your legislature than me. I'm not the right guy for that question. I can't hear you. Can you speak up?
Under penalty of perjury, in Arizona, apparently the paperwork states under belief. So are they
Under what?
Belief.
Under belief.
Okay.
So are they still held to the same level of immunity?
You'd have to parse the language in the verification. I don't remember. We have one of these issues in a case we're working right now, and I don't recall whether or not it specifically had the qualification language in it. But if they do, then it's a qualified statement. It's not perjury. You're going to have to actually show. See the way it works with Penal Code Section 125 is there's a presumption that they're making a known false statement if they don't qualify their verification. Do you understand? So what we do is if they don't say, I don't know this for sure, I just believe it to be true, if they don't say that, then the law will presume that they knew what they were saying was false, right? So here, where you have a situation where there is a qualification, says I'm informed, believe, and on that basis I say this horrible stuff about mom. Then you're actually going to have to go through the effort to prove not only that it was false, but that the affiant, the person signing the affidavit or verification, knew the information was false. The only benefit that we get out of Penal Code Section 125 is we don't have to prove those other two steps because it's presumed. So where you have a verification that is based on information belief, it's a two-step process. You will have to prove, number one, that the statements are false, and number two, that whoever signed it knew at the time they signed it, knew or should have known actually, was false. So I think that answers your question. Just one more and then that's it.
Hi, statute limitations, I hear
Yes.
about all the time, but what they do is they drag out all the services like the psychological evaluation and the counseling, and there's so many months that you have to get all this done. If you don't get all this done, then they can adopt your kid out. But then there's also a statute of limitations from the time the child was taken to where you can get an attorney.
Okay, let me make sure I understand your question. And I'll try and say it loud so y'all can hear it. If I'm understanding you correctly, what you're wondering is, you know there's a statute of limitations that will limit the time within which you can file your lawsuit, right? So far. And that in the context of these juvenile dependency cases, oftentimes they will get strung out and take a lot more time maybe than they should, and you're wondering how that conflicts with the statute of limitations for your civil case. Did I get that right?
Right.
Okay. That's a tricky situation. I'm actually really glad you asked the question because it encapsulates two different issues. One of them, during the break, a couple parents were talking to me outside about it. They had a question about whether or not they should file during the pendency of their ongoing juvenile case, whether they should go ahead and file their lawsuit. So this sort of plays together. Statute of limitations for 1983 is going to be determined by your state's general negligence statute of limitations. In California, the general negligence statute is 2 years. Some states are 3 years. I don't know what Arizona is. I think you guys are 2. You guys are 2 years. Now the way that you're going to get into that on the unwarranted seizure side of your case is pretty simple. You knew when they took the kid they didn't have a warrant. So the day they took the kid is the day the running of your statute of limitations on that claim starts. And you've got 2 years to file it. So what happens if you're, coming up on 2 years and you're still in there? That's a judgment call. I typically will tell parents when they call me, unless there's a really damn good reason for it. Hold on. Unless there's really a damn good reason for it, I will not file a civil rights case while you have your juvenile dependency case pending. The reason for that is, especially if you have a judicial deception situation, if you think they're treating you bad now, you think they're lying about you about things now, wait till you sue them. You're going to get screwed.
And also at the beginning, in Arizona, we have, it's 8-807, which specifically, and I'm dealing with that right now in another case, where if you basically go up against the state during an open dependency, and they believe that maybe information may have been leaked to to other, they will go after you. They will go after you. And I'm currently dealing with that with a case right now, a major case, and it's crazy.
Wow, yeah, that's tough. We don't have that out there.
They use it when it was written. It was supposed to be a shield to protect the families, their identities during the ongoing case.
Mm-hmm.
But if the families try to go out beyond what's going on, to kind of talk out to the press or otherwise, 8807 is being used by the Attorney General's office, in my opinion, as a sword instead of the shield to protect the families. They go after the people that are yelling the most and also protect the families. So
yeah, that's
please
bad.
be cautious about that. That's why I warn about putting personally identifiable information on the internet and other things too, and also going out. The Attorney General's office will come after you.
Yeah, that's out in California. It's a little bit different situation. We have Welfare and Institutions Code 827, which is the General Dependency Confidentiality Statute. The Ninth Circuit has held that, generally speaking, the general rule is it only adheres to documents. So if you have juvenile dependency or agency documents that specifically relate to your kids or your situation or whatever, it's unlawful. It's a misdemeanor to disseminate those without a court order. But it says 827 does nothing to prohibit you from, for example, in your complaint that you're going to file in federal court, talking about writing up your story. On such and such a date, Karen Wagner came in and seized my kids without a warrant. No problem in there writing that in your complaint. No problem going through the circumstances of her failed investigation. Those sorts of things. What you cannot do is actually take the documents that would prove what you're saying in your allegations is true. You cannot attach those to your complaint and file it. That would be a misdemeanor, and you'd get in trouble over that. So that's California, though. Arizona, it sounds like, is a totally different deal. So based on what we do in California, keep in mind when you're looking at our templates and stuff, keep in mind whatever local prescriptions you may have against, including specific identifiable information. One thing we do with the juveniles is we'll just use their initials in the complaint, and that it protects the kids somewhat, but anybody with half a brain can figure out who the kids are. They just look at who the parents are, and there you go, you have the names. But it is a requirement, at least out there in the federal district court, that we protect the identity of the children by just referencing their initials, and we do that.
That's for the county, not for private individuals.
No. The question was related to the prescription against disseminating the information protected by your state's privacy statutes that relate to juvenile dependency court. In California, it's a misdemeanor to disseminate the documents without a court order. You can talk about the information, that sort of thing. You can't disseminate documents. Here in Arizona, from what I understand, it's a much broader statute and penalties attached for even talking about it. So that's another issue. Those arguments have been made and failed. I think that the better approach is to take a very close look at your state's juvenile dependency confidentiality statute and see what it says. Because like I said, California is very different from Arizona. I suspect that, you know, South Carolina, Michigan, they're all going to be different. So that they'll be similar but different.
Is that just during the pendency of the case, or are we talking about afterward as well?
I'm talking about during well, you know, it's hard to say. Does it apply out here afterwards as well?
Yeah. Actually, afterwards too.
Okay.
And again, I'm dealing with a big case right now, which actually has been closed, but the Attorney General's office is going after me, accusing me of violating 8807. So I have to defend myself on a sealed case that's over because of an accusation I violated 8807 at some point. And then I was told, and the argument has been made, and it was agreed with, that it's always a dependency case is always considered
Okay.
a sealed procedure.
Well, that's true. That's true in California too. What she's saying is that a dependency case is always considered a sealed under the statute. That's true in California as well. 827 Welfare and Institutions Code Section 827 will apply across the board throughout, I guess, all time. Even a juvenile who, once they become an adult, wants to go back and look at their record, they have to go in, they have to apply to the court to get an order to get the record opened up just for them. And typically a protective order will be issued that says, okay, here's your records, but you can't disseminate them to anybody for any, to anybody for any purpose without a further court order. So in that sense, we're probably very similar.
Isn't that kind of an evidence conspiracy right there to suppress the evidence?
Well, hold on. You're all having similar. You're all having similar questions. That happens all the time. That's something you. That's something you got to work out in the litigation. But the real question I heard there was the First Amendment, the crossover with the First Amendment, and that's been resolved. Where we get into some tension in the civil rights litigation is, at least in the Ninth Circuit, the juvenile courts like to control the flow of the information. They don't want to necessarily give you the entire file. They don't want to necessarily give you the entire agency file. You know, there's the court file and the agency file. They don't want to necessarily give you both. They will invariably give you some. But at least in the Ninth Circuit, we run into preemption issues because under federal law, we want to encourage people to file lawsuits against the government to vindicate their federal rights. Okay? We cannot disable them in that effort by cutting off access to essential discovery, essential information, essential documents that are maintained by the state. So in the Ninth Circuit, and I've got briefing on this on the thing, you can go ahead and pull it up. In the Ninth Circuit, that includes Arizona for everybody really, there's this tension, and the federal courts have decided that they have authority to go ahead and order the state to produce those records in their entirety. Now, what they will do is they will look at the particular state, or the particular forum state's rules. In California, it's Welfare and Institutions Code 827. They'll look at those rules and then do the similar analysis that a juvenile court might do in releasing the records, but I think you're going to get a much fairer shake out of the federal judge who's familiar with the case, who's working, hopefully going to be your trial judge. You're going to get a much better shake out of him or her when they issue that order than you may get out of, the King's Court. So that's basically where I'm at. Probably ought to edit that last part out.
What they do is they seal the juvenile court record when you're suing them in federal court at the same time?
No, it's sealed by statute. It's sealed by statute. The moment they open up a case, you can't go in and
How do you get it from state
Well, that protective order was probably issued so that you could get documents at all. But let's do this. Let's not get bogged down in discovery stuff. Let's keep moving. I think before the break, I said I was only going to answer a few more questions. We'll have another break later. I'll answer more questions. But before the break, we had just started, as I recall, and you guys correct me if I'm wrong, talking about the judicial deception claim. Is that right? Yes. Okay. And as far as I recall, we had just started on that. We had dealt with statements under penalty of perjury, unqualified statements under penalty of perjury, and how we might go about attacking those under a judicial deception claim. And to sort of give you the background for that, that's a claim that's going to arise under the 14th Amendment, not the 4th Amendment, unless, of course, the child was seized based on a fraudulent warrant. Then that's a completely different analysis, and if you guys need to talk about that, we can talk about it later. But the general analysis that we're looking at on a judicial deception claim is going to be the circumstance where we have a petition that was filed, signed under penalty of perjury, contains a bunch of false information. It's supported by the detention report or whatever it is, the preliminary hearing. Preliminary protective hearing court report in Arizona. I like detention report better. I'm going to use that. And that detention report will contain, ostensibly, all of the information gathered by the investigator during their investigation, and they're required to give it to the court so that the court can have the full picture and then make a decision, yeah, give the kid back, or no, continue to detain the child because it looks like the kid's in danger. Now, the focus of your judicial deception claim generally is going to be on that report. Because what happens, and every social worker that I've ever deposed, I've deposed like 140 of these people, they all say the same thing, and they all know it. I'm going to use California language again for you guys. The detention report is the primary evidentiary document that the judge will rely on at the detention hearing. And what happens at that first hearing, I'm not sure if Arizona is the same or not, but in California what happens at that hearing, the judge looks at the petition, and then the government is required to make only a prima facie showing that the child is in danger. So what they'll do in their detention report is they'll heap in all kinds of crap that is just wrong, or they'll twist it and turn it. It may technically be true, but they'll present it in such a way that it makes the parent or caregiver look really, really bad. And they'll leave out all the exculpatory information. That is the information that would undermine the credibility of the allegations against the parent. Under federal law, they can't do that. All right? The judge, when he's making, when he or she is making their decision at that first hearing, that prima facie finding, they have to have all the information. They have to have everything about this family that was discovered in order to determine whether or not to give the kid back or keep the kid. And the reason that we do that, the reason we want the judges to have all that information, is because they're making a pretty serious decision that's going to impact a lot of people, parents, kids, extended family, and it's going to have an impact that lasts a long time. There's a study, Dr. Charles Sophie, he's the medical director of County of Los Angeles. There's a study that he did, and he gave a lecture to all of their social workers, explaining to them why they want to be really careful when they're seizing kids from their home, even in abusive situations, even where the kid really is being abused, it causes permanent neuronal changes. So we want to be really, really careful. I think I might have published that on YouTube too. So we want to be really careful seizing kids. And the judges, they know that too. And that's why the social workers, when they're making these reports, they have to be complete, honest, and accurate. They've got to give up everything and then let the judge decide what to do with the kid. Now, the problem we face in these judicial deception claims, and we get a lot of them, is that the social workers don't tell the judge typically all the favorable or any of the favorable information. A good example, or they make things up. They'll just straight out lie. A good example is this case we just did in Los Angeles. It was a failure to thrive case. The woman lost her child for when he was, 15 months old for the last 7 years. And it was a tough case. And what happened there is the social worker and the mom's father, so the maternal grandfather, got into a little tiff. The maternal grandfather called the social worker white trash and her supervisor a cockroach. And the moment that happened, the supervisor and the social worker said, "We're done. We're done with you." Took the kid, no warrant, no nothing, gave him to the father. So then, years later, we get involved, and I get the detention report. And I told you, the first thing we do is we listen to the parent's story, and then we look at all the records to see what's in there. And in the detention report, there's this entry there by the social worker, Susan Pender's her name, and she says that she went out and talked to the child's doctor, primary pediatrician, and that the pediatrician said all these horrible things about mom, how she's not following the doctor's instructions or advice, how she's got her own agenda. I mean, just all this crap. And I read that and I thought, wow, that's pretty serious. If she really said all this stuff, we're dead in the water. We don't really have a case. So I called her. I called the doctor on the phone. This is for the attorneys out there. You guys, you got to do your groundwork. Just because you read something in a report by a social worker that's signed under penalty of perjury, you can't presume it's true. So anyway, that's serious stuff. So I call the doctor on the phone. And I say, "Hey, look, doctor, I got this thing, and the social worker, she's saying you said some pretty bad stuff." He said, "Well, you know what? Let me do a call a little bit later. Let me go look at my chart. Anything like that, it would be in my chart." Because remember, it's 7 years later. And so we arrange another call. I call her back and I say, "Okay, well, let's talk about this now. What's going on?" She says, "Well, I don't remember ever having a conversation with any social worker. I just don't think that first of all, I would never say that about a parent. And secondarily, if I didn't have a HIPAA waiver on file, I wouldn't talk to anybody about this parent. And I certainly wouldn't take a call just out of the blue from somebody claiming they're a social worker or something. They got to show me and give me a subpoena, and if I see a problem, we'll deal with it." I said, "Well, maybe you just don't remember. This happened 7 years ago." And she says, "No, I told you I'd go back and look at my chart. Anything like this would have been charted. And there is nothing. I never talked to that woman. I can tell you with certainty. I never talked to that woman, and never about this parent." So at that point, we said, "Okay, we got a case." And you put that in the complaint, and bang, we're away and running. At trial, she came in. She was much better at trial than she was on the phone. It was great. I wish we could have videoed that. But the defense attorney is beating up on her, all this stuff about how it's so long ago. And I guess she had done a whole bunch of other independent research on her own because she thought, well, maybe, one of the other doctors or somebody else, something might have happened. And she was able to come in and say, not only me, but nobody at my office ever. It just didn't happen. Unfortunately, in that case, on a motion for directed verdict, the judge took away the question of judicial deception from the jury, saying that it was up to the court to determine the materiality of the false statements. That's whether or not the false statements were essential to the outcome in the juvenile dependency case. And he found against us. He said, "Oh no, they're not. The judge might have come to a different decision if this information had been known, but I can't definitively say that, he would have or she would have." So that sort of dovetails into that jury instruction issue I was talking to you guys about earlier. The new jury instruction that's coming out says he's wrong. That the jury gets to decide the materiality question. The jury gets to decide whether the outcome would have been different had that information been disclosed or had the false information not been inserted into the record before the judge. So there's a conflict there. We're going to get it sorted out on appeal. Maybe the next time I'm out here, 2 or 3 years from now when we have a decision on that, it'll be our way. But I think, judicial deception. So that would have been sort of an omission. I don't know, actually it's a false statement. It could be omitting to tell the court that the social worker never called the doctor, but on the other hand, it's a lie because the social worker affirmatively said under penalty of perjury, I called Dr. Gill. So, and we know it didn't happen. Dr. Gill told us it didn't happen. So that's what you're looking for. That's the character of evidence that you're looking for when you're looking for a judicial deception claim. Is the social worker coming out under penalty of perjury and affirmatively saying something that is important to the outcome of the case that's not true. Okay, that's step number one. There's another type of, or I guess classification number one. There's another type of judicial deception claim that relies on omission of exculpatory evidence. And you'll see that most of these social workers, at least the ones I've deposed out here in Arizona and in California, they don't even know what exculpatory means. And it's sort of odd because they say, you can ask them, well, you know, to do your job, you kind of have to have at least a rudimentary understanding of the law that governs the work you do, right? Yes. Okay. And so what's exculpatory evidence, do you know? Oh, well, I don't know what you mean by exculpatory. Then you ask them, well, what do you call evidence that would show the parent just didn't do whatever it is you're claiming they did? So, I don't know, evidence. It's like, oh my God. So that's another thing that you want to look for. If there's anything that should have been disclosed to the court but wasn't, that's another flavor of judicial deception claim. And you'll get several of these things. In every case, you'll get them making stuff up that's just not true. You'll get them not disclosing stuff. You'll get them taking things that are true and twisting them and turning them so it makes the parent look bad. So that all these different types of information, they all come under the judicial deception rubric. And
Cause of action for everyone though?
No. You're going to have basically, and here we're just talking about the federal claims, not the state claims, because you may have all gobs of state claims. So on the federal claims, you're going to have two basic claims for relief. For attorneys, it's a little bit different. For the pro pers, you're going to just have a claim for relief on your own behalf under the 14th Amendment for unwarranted seizure. And that's where they take the child without a warrant when there's no emergent circumstance. Then your second claim for relief is going to also be under the 14th Amendment for judicial deception, or another way of presenting it would be for the deceptive presentation of evidence in the juvenile court. So that's basically it. You're going to have two claims for relief. If you're in a state that that has the counties administering the agency, then you're going to also have a Monell claim, and that's and you can sort of lump your unwarranted seizure claim and your judicial deception claim together when you're addressing Monell, and so that would be your third claim for relief. And since you're attorneys, you're also probably going to have the ability to represent the children, and they have claims that arise under the 4th Amendment for the seizure and the 14th Amendment for the judicial deception. Now, I told you earlier that we'd talk a little bit for the attorneys about the situation where you have a warrant that was obtained, because some states are starting to get warrants. They're figuring out that, you know, it's costing them a lot of money to not get warrants. They're starting to do it. But that hasn't really changed anything. What they've done is, it's like we're like mice in a maze chasing cheese, and all they've really done is move the cheese. What happens now, and we see a lot of this in the counties where they're getting warrants now, is they have to fill out an affidavit to support a warrant, right? They'll just lie in the affidavit. So all the same crap that you see in your detention report, it'll just get moved in the affidavit to support the warrant. And the way that you attack those, ultimately, it's going to be a 4th Amendment claim and a 14th Amendment claim. Because we go after the affidavit. Once you get it stricken, then you treat the child as if they were seized without a warrant. So you still have to look at whether or not there's an exigency, that sort of thing. But you have an additional little sliver claim off on the side for judicial deception in the warrant application itself. So there's a little bit of a distinction there. I'm not sure how critical it is that you really draw the distinction in your pleadings, because it's going to get addressed in the briefing anyway when they do their motion for summary judgment. So we address it in the pleadings. Just because it's simpler then, and it keeps everything straight and clean as you're working your way through the process. But it's really up to you guys how you do it. It's a matter of preference. So what else do we have after that? Out in Arizona, you guys don't have to worry about the Monell claim because you're not going to have one. And for the pro pers, you don't have to worry about Fourth Amendment because you weren't seized. Fourth Amendment's a personal right to the person that was actually seized and detained. So as a parent or grandparent or caregiver, you're not going to have standing. Yep, sorry. I knew I was doing that. I was trailing off. I do that when I'm just thinking. Basically what I was saying is that as a pro per, you don't have to worry about the Fourth Amendment claims because the Fourth Amendment is a personal right, and it's personal to the person who's actually seized or detained or searched. And that would be the kids, and you don't have any standing to pursue the kids' claims.
So if a kid turned 18?
They can do their own claim when they turn 18. That's correct.
And there's not a statute?
What do you do about the initial disclosures requirement with the complaint? What are you disclosing to?
What do you mean, the Rule 26?
Yeah, in the feds.
Rule 26, it has its own fairly substantial body of jurisprudence that governs what you're required to disclose and the penalties for not disclosing. Generally, what we'll do on our Rule 26 disclosures, by the time we get to that point, we really front load the work on our cases. We don't actually even file the complaint until we've got as much information in terms of records and everything else, talk to witnesses as we can get before we even file the complaint. So generally, we'll have everything we need to support it at the time we file it. The Rule 26 disclosures, if you work your case that way, the Rule 26 disclosures are really pretty simple and perfunctory. You just throw it all together, here you go. Put it on a DVD, give them the documents, give them your witnesses, give them everything.
Do you have the confidentiality issue though, or?
It's Rule 26 disclosure. It doesn't get publicly filed.
Okay.
Yeah, it's just between counsel. Okay. You know what? Let's hold on a second on questions because I have to think a minute because I'm not sure that we're through the judicial deception stuff. I wanted to get today through the basic structure of a complaint. And where we are so far, we covered the jurisdictional and venue requirements. We covered the parties. We covered the story. We covered the causes of action or claims for relief. We've gone through warrantless seizure claim for relief. We've gone through judicial deception claim for relief, both flavors. And I think that's it. I think that pretty much covers it. So I guess, why don't we do this? Let's take a 5-minute break so I can go pee, and then we'll answer questions. Yeah, I'm an open book. What can I tell you?